Oh. All right, go ahead. Start this mic breaks. Yes, please sit. We're not, we have to do roll call first. Wait. Okay. Okay, thanks. Right.
Okay.
Good morning. We're going to call the Nevada Commission on Ethics meeting to order. First, we will do roll call. Chair Wallen here, Vice Chair Dufferin.
Here.
Commissioner Grunwald. Here. Commissioner Lowry.
Here.
Commissioner
Here.
Yin. Commissioner Towler.
Here.
And Commissioner Oscarson and Commissioner Sheets are excused. From staff, we have Commission Counsel Chase. Here. Executive Director Armstrong.
Here.
Associate Counsel Bassett. Here. Senior Legal Researcher Hayden.
Here.
Executive Assistant Pedroza.
Here.
And Investigator Terry.
Here.
This time we will do the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. At this time, we're at public comment. I'd like to ask the Executive Director if the Commission has any members of the public here, or if you've received any emails for public comment.
This is Executive Director Armstrong. We've received no written comment prior to this meeting. I will defer to Ms. Pedroza for anyone on the Zoom.
We do not have any members of the public on Zoom wishing to make public comment.
All right, thank you. Next item, item 3, approval of the May 18th Commission minutes. All commissioners were present and may participate on this item. I'd like to ask my fellow commissioners, are there any additions or corrections to the minutes as read? All right, seeing none, I'll entertain a motion to approve.
I move to approve the minutes as presented.
Is there a second? All
I'll second.
right, all those in favor say aye.
Aye.
Aye. Opposed? Motion carries. Next item is item number 4. Discussion and approval of proposed stipulation concerning ethics complaint number 20-064C regarding Steve Alford, head men's basketball coach, University of Nevada, Reno, State of Nevada. The review panel members, Vice Chair Dufferin and Commissioners Grunwald and Oscarson may not participate on this item. Further, Commissioner Yin will have a disclosure and she will be abstaining because her law firm represents UNR. The participating members are Chair Wallen and Commissioners Lowry and Towler. I would like to call the item and indicate for the record that the members of the review panel, Vice Chair Dufferin and Commissioners Greenwald and Oscarson will not be participating on this item pursuant to NRS 281A.2204. Commissioner Yin, do you have a disclosure to make for the record?
Yes, thank you, Chair Wallen. I do have a disclosure for the record. I am a partner with the law firm of McDonald Carano, of which the University of Nevada, Reno is a client. UNR employs Mr. Alford in a private capacity. Thus, pursuant to NRS 281A.065 subsections 4 and 5, I have a commitment in a private capacity to my law firm and UNR based upon the law firm's continuing business relationship with that client. Consequently, the independence of judgment of a reasonable person in my situation could be materially affected in voting upon items related to Mr. Alford. In order to avoid conflicts of interest and any appearance of impropriety, including complying with the ethics law and judicial canons applicable to the commission, I am disclosing these relationships and will abstain from participation in this matter. I've consulted with Commission Counsel Chase, and she agrees with my disclosure and abstention is required in this matter. Thank you.
Thank you. I want to indicate for the record that Mr. Alford has been provided proper notice of this item and is represented by his counsel in these proceedings. I would like now to ask the parties to identify themselves for the record.
Good morning, this is Elizabeth Bassett, Associate Counsel for the Executive Director.
And for Mr. Alford.
Chief Deputy Attorney General Greg Ott, also joined on Zoom by Senior Deputy Attorney General James Balatin for Mr. Alford.
Thank you. I would like to now ask for a presentation from Associate Counsel Bassett.
Good morning, Commissioners. This is regarding ethics complaint case number 20-064C regarding Steve Alford, subject, the head men's basketball coach at the University of Nevada, Reno. The Commission received an ethics complaint on September 8th, 2020, alleging that Mr. Alford violated NRS 281A 400 subsections 1, 2, 3, and 10, and NRS 281A 420 subsections 1 and 3. The Commission entered an order on jurisdiction and investigation and directed the Executive Director to investigate the allegations, which the Executive Director did, and Mr. Alford provided a response to the complaint. On August 18th, 2021, the review panel referred the complaint to the Commission for further proceedings. In lieu of an adjudicatory hearing, Mr. Alford and the Executive Director have agreed to the proposed stipulation that's before you this morning for your approval. Mr. Alford is the head of the University of Nevada now, and as such is a public employee. Mr. Alford was formerly employed as the Director of Player Development for UNR men's basketball team during the 2019 to 2021 basketball season. Beginning the following season in 2020-2021, Corey was hired as the head men's basketball coach at Huntington University, a private university in Indiana. UNR plays both conference games, which are games against member universities within the Mountain West Conference, and non-conference games. And the purpose of the non-conference games is to increase competitiveness, their profile, and for player development. During the time period associated with the ethics complaint, UNR delegated the proposal of non-conference opponents to the head men's basketball coach, athletics, which at that time was Doug Muth. The non-conference games are usually fall into 3 categories: tournaments, which they pay an admission fee for, home games and home series for which no financial consideration is paid, and guarantee games, where one team pays a fee to the other team depending on who travels. For 2020-2021, UNR men's basketball team had a $250,000 budget for the non-conference schedule. Initially, UNR had a guaranteed game schedule against Southern Utah, for which UNR was going to be paying Southern Utah $85,000. However, that game was canceled due to COVID. This was during the height of COVID going on. UNR and Huntington thereafter entered into a contract to fill the spot left by Southern Utah cancellation. And the contract specified the game would be played in Reno. Huntington would be paid $40,000 for belongs to non-monetary compensation, which included hotel rooms and flights, some other considerations. The contract was executed by the athletic directors for each university, including Mr. Muth, and was also subsequently signed by the head coach of each men's basketball team, meaning Mr. Alford and his son, Corey Alford. The game between the universities was never played. It was ultimately canceled due to COVID, so no compensation was ever paid under the contract. The investigation showed that the amount of compensation paid under the contract was consistent with what was paid to similar universities in similar circumstances. The investigation ultimately also showed that the for a game of this type, when a assistant type coach moves into a head coach position from under a coach out into a head coach position is standard at UNR and elsewhere. So this was not specific to being the son of Mr. Alford, but any coach who received a head coach job after serving under a coach at UNR. So although both signatories were father and son, the fact of payment for a game in this instance itself was standard practice. The executive director and Mr. Alford have agreed to the following proposed stipulations. The allegation that Mr. Alford violated NRS 281A 400 subsections 1, 2, 3, and 10 in NRS 281A 423 would be dismissed by stipulation of the parties. And Mr. Alford would agree to stipulate to a non-willful violation of NRS 281A.421 for his failure to disclose this conflict of interest in that he signed a contract with his son. The reason, the mitigating factors that we believe are at play that support this particular outcome include the seriousness of the violation. Mr. Alford failed to properly disclose his relationship to his son, but he never hid their relationship. It was a well-known fact at UNR and elsewhere. In fact, UNR itself announced the hiring of the son, Corey's hiring as the head men's basketball coach at Huntington, and in fact, they wanted this game to go forward because they thought actually it would make for great press that Steve Alford and Corey Alford's teams would be playing for each other would be a good thing for press. So it was, although he failed to disclose, it wasn't a hidden fact. The seriousness of the violation is further reduced because the performance of the contract was never completed. Therefore, no financial consideration was ever paid. Mr. Alford has never previously been the subject of any violation of the ethics law or previous ethics complaints. Mr. Alford was diligent to cooperate with and participate in our investigation and resolution of the matter, which means that his cooperation greatly reduced the cost and expense to us in undergoing that investigation and moving forward with the case. Although Mr. Alford did not self-report or self-correct in this matter, his willingness to engage in the process has resulted in a better understanding of Nevada ethics laws. Mr. Alford, during the process of going through this investigation and process, has requested that UNR revise the procedure for the approval and execution of future non-conference games to prevent future non-willful violations. The contract was not completed and no amounts were ever paid under the contract, therefore no restitution was paid because no amounts were ever paid. And the contract, even if completed, would not have resulted in any direct payments personally either to Steve Alford or Corey Alford. And ultimately neither Mr. Alford nor his son receiving the financial benefit as a result of the contract. The contract itself, aside from being executed by father and son on behalf of their respective employers, was not outside the ordinary course of business for a basketball team and was an amount less than the contract it replaced. And additionally, one thing that we looked at in this case was the fact that Mr. Alford was not provided with any legal or ethical advice or training from UNR. No counsel ever reviewed this contract. Even though the school was well aware it was going to be signed by Mr. Alford and his son, no one ever, gave them any advice or counsel on how to handle this contract. And there previously had been no ethics training for either Mr. Alford or the athletic director signing in. They did not routinely look at any of these contracts. And there's been a movement to change that process in the future. Mr. Alford, as part of this agreement, agrees to complete ethics training within 60 days of the approval of this agreement. He would agree to an admonishment from the commission to familiarize himself with the ethics law for the purpose of making proper disclosures in the future and in furtherance of complying with applicable requirements of the ethics law. Given the facts and circumstances present in this matter and the mitigating factors that are present, and the overall information that we obtained during the investigation, the executive director and I believe that the terms of the stipulated agreement are appropriate, and we do recommend that it be approved. I'm happy to answer any questions that you may have.
Okay. First, I will ask if Mr. Ott or Mr. Bolton have any further comments to add to Ms. Bassett's presentation.
Deputy Attorney General Greg Ott, no, she summarized it very well. I think the stipulations represents the agreed positions.
Okay. Mr. Bolton?
I agree with Mr. Ott's representations, and I agree that Ms. Bassett's presentation accurately reflects what was agreed to in the stipulation.
All right.
Madam Chair,
Yes.
Tracy Chase, Commission Counsel for the record. I just want to put a clarification in the record, and I caught it when I heard Associate Counsel Bassett's presentation. In the stipulation, it says that Mr. Alford is going to basically encourage UNR basically to take steps to prevent a future non-willful violation. I just want to put on the record that each case is reviewed by the commission independently. Whether or not the commission would determine a future case is willful or non-willful will be dependent on the facts of that case. So actually, Mr. Alford's conduct would be to prevent any future violation, non-willful or willful, because I did not want the stipulation to pigeonhole the commission itself in any predetermined decision on a set of facts it hasn't heard.
This is Associate Counsel Bassett. I may have misspoke in this. I was wondering.
Actually, I think that's in a
Oh.
stipulation. I just caught it. That language is, you were accurate in your representation. And maybe we can just clear that up afterwards so that the stipulation accurately reflects, because I didn't want anyone to have a preconceived notion that this stipulation would bind the commission in any future allegations that come before it.
All right. Fellow commissioners, questions for Ms. Bassett? Or even for council? No? Okay. I don't know if this is a question or not. I know that in previous cases, we've had people not just take the ethics training, but then we encourage them to have the rest of their department or whether do that. And I was wondering why we don't have something like that. And my other question is, and it gets to improving their processes for contracting and making sure that these types of things don't happen in the future. In the past, we've gotten something that shows how they have improved their process, some, in their policy or whatever. Are we looking for that? I'm not too clear about this.
And I'll have Mr. Rock correct me if I'm incorrect on this. So this all took place a little bit in 2020, obviously. And UNR actually has conducted its own internal investigation as well. And actually ethics training specific to this situation has already taken place. I know the outgoing athletic director, now he's gone, but I know he specifically was tasked with ethics training as a result of his part in this, as sort of senior overseeing person signing this contract. So I know there was movement to, from my understanding, there was ethics training that took place in the department already. And that is why it was only specific to Mr. Alford in this instance. Because I think that has already taken place. As to other people within the department, based on UNR's own. UNR had an outside counsel investigating for the same concerns that were raised in the ethics complaint.
Deputy Attorney General Greg Ott, I believe that's accurate. I don't want to, well, I haven't looked at the report recently, so I couldn't tell you exactly how far that training went. I know there was some training component. Also don't represent UNR, so I can't represent what they would be obligated to do. I think that you heard from the presentation that Mr. Alford didn't get the oversight or the support that I think he probably would have liked to have gotten. And I think that he would probably advocate for that within the university. It's not in the stipulation, but I think that some of it's already been done, and yes. And then I don't know if you want to address the second point as well.
Which was the second, I'm sorry.
the second point is, we're talking about, they said that they're going to change their process, so this doesn't happen. And like in some previous cases, when we've done that, they've had to come to us to show us the document that they have approved to follow.
I think the difference in this case is that we don't have UNR at the table in this instance, like we had, like in another case, you know, the city of Reno was willing to come to the table because of the process we worked through, which was a deferral agreement, which we don't have UNR at the table in this particular matter. You know, certainly might be able to reach out and see if they'll work with us. I know in our next stipulation, we're going to discuss those. Also, you know, some requests to reach out and encourage them through their athletic department to remind people they are public employees and officers and are subject to this law, because that's, I think there might be some oversight on this part there, and to do some training. I mean, that might certainly be something we might want to put on our schedule. But I mean, I'm sure we could, you know, discuss having them, I mean, hopefully Mr. Ott and I might be able to work out, like, reaching out to UNR's department and having them do maybe a broader training approaches.
Certainly, and Deputy Attorney General Greg Ott, and I will say that we have had conversations about the future, right? Not just this specific instance. Statutorily, this is a new position for our office because we're assigned to defend violations, not necessarily to counsel other bodies on ethics training, and they have other lawyers for that sort of thing. But without any case law to support me, I think that the representation that we've been tasked with in the statute is broad enough that it could encompass trying to do some of this cleanup work or an improvement in processes for the future. And certainly I'm happy to work with Ms. Bassett or Director Armstrong with regard to trying to make sure that things are better in the future, because I believe that this would have been a positive game for the university. And I think that there is a way to schedule it within the confines of the ethics law. And we just need to make sure that that gets set up in a way that everybody feels comfortable with.
And then the training was the training through our office? Or
Yes.
All right. Okay. All right. Well, thank you. And I appreciate your cooperation and helpfulness in this case. And, it really makes a difference, and we appreciate that. So any other questions from the commissioners who can participate? Right, seeing none, then I will entertain a motion from the commissioners who can participate to approve the stipulation number 20-064C for Steve Alford as presented, and authorize commission counsel to finalize the stipulations on behalf of the commission, including clarifying the language in the willful, non-willful part. Do I have a motion to that effect? Right, Commissioner Lowry?
I move to approve the stipulation in case number 20-064C as presented, and authorize commission counsel to finalize the stipulation with the amendments indicated by commission counsel during the discussion on behalf of the commission.
Right, is there a second?
Second.
Right, all in favor, say aye.
Aye.
Aye. Opposed, motion carries. All right, well, thank you very much, and thank you for your participation and helping us take care of this matter. And I look forward to your working with the Ethics Commission and making it even better. So, thank you.
Thank you.
Thank you very much.
Thank you.
All right, next item is item number 5. Discussion and approval of a proposed stipulation concerning ethics complaint number 22-038C regarding Corey Alford, former director of player development, University of Nevada, Reno, state of Nevada. There was no review panel except for Commissioner Sheets is excused, and Yin and all other commissioners may participate on this item. And Commissioner Yin, I would like to ask if you have a disclosure to make for the record at this time.
Yes, thank you, Chair Wallen. I do have a disclosure for the record. I am a partner with the law firm of McDonald Crono, of which the University of Nevada, Reno is a client. UNR previously employed Mr. Alford in a private capacity at times related to this item. Therefore, pursuant to NRS 281A.065 subsections 4 and 5, I have a commitment in a private capacity to my law firm and UNR based upon the law firm's continuing business relationship with that client. Consequently, the independence of judgment of a reasonable person in my situation could be materially affected in voting upon items related to Mr. Alford. To avoid conflicts of interest and any appearance of impropriety, including complying with the ethics law and judicial canons applicable to the commission, I am disclosing these relationships and will abstain from participation in this matter. I've consulted with Commission Counsel Chase, and she agrees my disclosure and abstention is required in this matter. Thank you.
Right, thank you very much. As I indicated for the record, that since Mr. Alford waived the review panel proceedings, all commissioners may participate on this item, except for Commissioner Yan, who is abstaining. I want to indicate for the record that Mr. Alford has been provided proper notice of this item as is represented himself in these proceedings. This time I would ask Associate Counsel Bassett, identify herself and all parties, including Mr. Alford, for the record.
Good morning, Associate Counsel Bassett, representing the executive director.
Okay. Good morning, Mr. Alford. Please identify yourself for the record.
Good morning, Corey Alford.
Thank you. This time I'd like a presentation from Associate Counsel Bassett.
Good morning. There are some of the same facts again, but we'll run through them. This is concerning ethics complaint case number 22-038C regarding Corey Alford, former Director of Player Development at UNR. The commission received, this one actually, the commission brought its own motion in April 19th, 2022. And Mr. Alford has agreed to waive the review panel, and in lieu of an adjudicatory hearing, we are bringing the proposed stipulation to the secretary today. Mr. Alford served as the Director of Player Development at UNR from May 2019 until April 30th, 2020. On April 11th of 2020, Mr. Alford accepted the position of head men's basketball coach at Huntington University, a private university at Indiana, where he's still employed. After accepting the Huntington position, but while still employed at UNR, Mr. Alford and his father, UNR's men's basketball head coach, Steve Alford, negotiated a contract between Huntington and UNR for a non-conference guarantee basketball game for which UNR was to pay Huntington to travel to UNR. UNR's non-conference schedule originally included a guarantee game against Southern Utah University, for which UNR would be paying $85,000. However, that game was canceled due to COVID concerns. The Huntington game contemplated by the contract replaced this game, and the contract called for payment by UNR to Huntington of $40,000, some free hotels, and on April 14th, Mr. Alford's new role at Huntington was publicly announced, including through a press release on UNR's website. On that same date, Mr. Alford sent an email to UNR's Assistant Athletics Director for Finance, informing him of UNR's men's basketball schedule, including the terms of the contract for the non-conference guarantee game between Huntington and UNR. On May 1st, Mr. Alford began his position at Huntington. The contract between Huntington and UNR was first signed by Huntington's athletic director, Ms. Kohler, on April 30th, by Mr. Alford on May 1st, his first day of employment by Huntington. It was then transmitted to UNR, where it was signed by UNR athletic director Doug Muth on May 1st, and subsequently by Steve Alford with an undated signature. The contract was never performed, the game was never played due to COVID concerns. Similarly to previous stipulation, the executive director and Mr. Alford have proposed to enter into the following stipulations: that Mr. Alford, that the allegations that Mr. Alford violated NRS 281A 400 subsections 3, 5, and 7, and NRS 281A.421 would be dismissed by stipulation, and that Mr. Alford's actions would be found to constitute a single course of conduct under NRS 281A.400 subsection 10, and that would be found to be a non-willful violation. The basis for that finding of a non-willful violation would be based on the following mitigating factors. Mr. Alford was employed by UNR at the time he sought the contract for his future employer, Huntington. However, he had already removed, with UNR's consent, he had already removed all of his belongings from his office, and he had already commenced relocating himself and his family to Indiana. He had terminated his duties related to UNR, other than the one last duty of helping to finalize this conference schedule for UNR, which included securing the contract to replace the canceled game of Southern Utah. He did not, Mr. Alford didn't try to hide or attempt to conceal the contract. He did not sign the contract on behalf of both parties, but waited until his official start date at Huntington to sign it. And the seriousness of the violation is further reduced because the contract was never performed. Mr. Alford has never previously been the subject of any violation of the ethics law or previous ethics complaints. Mr. Alford was very diligent in cooperating with and participating in our investigation and resolution. And in fact, that included in waiving his right to a review panel and engaging with us in our investigatory efforts right away and agreeing to a stipulated resolution very early in the process. Although there was no self-reporting or self-correction, his willingness to engage in the process has resulted in a better understanding of ethics law and how his actions were improper in this matter. There's no restitution paid, however, there was no performance of the contract and there was no financial benefit or any financial payment of any kind. Mr. Alford did not receive any direct financial benefit as a result of his conduct, and he would not have even if the and he would not have received any personal payment under the terms of the contract, even if it had been performed in full. And the contract itself, aside from being executed by father and son on behalf of the respective employers, was not outside the ordinary course of business for the basketball team, and was for an amount less than the Southern Utah game contract it replaced. And in addition, Mr. Alford was not provided with any legal or ethical advice or training from UNR or its athletic or legal department regarding how to properly handle the execution of the contract. Even the UNR's athletic director was aware that Alford would be signing the contract and it's Steve Alford's son. Mr. Alford has agreed to complete ethics training in Indiana, where he's now employed within 60 days of approval of this agreement. We've looked into that and figured out where he will be taking that training and what that includes. Mr. Alford has agreed to write a letter to the UNR president and athletic director, copy to our commission, encouraging them to adopt an ethics training program so that other public employees are provided with appropriate training to avoid similar ethics violations in the future. He's agreed to acknowledge what was improper about his action and accept an admonishment from the commission relating to his conduct in this matter. Again, given the facts and circumstances of this matter, what we were able to determine during the investigation, the executive director and I believe the terms of the stipulated agreement are appropriate and do recommend that it be approved. I am happy to answer any questions that the commission might have.
Okay. Mr. Alford, do you have any additional comments or additions to Ms. Bassett's presentation?
I do not. Liz represented the agreement well.
Okay, thank you. Fellow commissioners, any questions for Commission Counsel or Mr. Alford? Or Associate Counsel? Sorry.
Madam Chair, I had a couple
Yes.
questions.
Vice Chair Duffer.
So the stipulated agreement talks about Mr. Alford getting ethics training in Indiana. So is the ethics training that's proposed, because I'm not familiar with Indiana's ethics laws. I don't even know if they even have ethics laws, but you're telling me that maybe they do. Okay, that's good. So the specific issue that we have before us today, do their ethics laws address any of this? So the crux of my question is I want to make sure Mr. Alford has proper either proper training or proper counsel, so he never gets into this situation again. So, I mean, we could, if he was still here, we would be happy to sit down with him and his father and go through all the issues. But he's not. And once again, Mr. Alford, thank you for appearing via Zoom, and it shows me that you are cooperative and that you do take this very seriously, and I appreciate that. So that's my question.
And this is Associate Council Bassett. That was exactly sort of the intention of putting this in here, was since he's no longer in Nevada, doing Nevada ethics training has pretty limited utility at this point, since he's no longer employed in Nevada. So the executive director and I looked what would be a good comparable, stipulation. And so we looked at, Indiana does have ethics, they have an ethics commission, they have an ethics commission that does ethics training, similar to ours. They do have similar disclosure and abstention laws that we do. We looked at their training and it is very similar. So, and they had to do it was very similar to like training we have. And so that was exactly the intent, was that this situation, when you look into it from an investigation standpoint, really flowed from a lack of training and oversight in a lot of ways. It appeared. And so, right. So making people knowledgeable that these laws do apply and how to avoid this kind of a situation in the future. And it does appear from reviewing the training that the Indiana Ethics Commission does, it appears that would be useful and applicable.
And this is Executive Director Armstrong. Whenever we have a stipulation or a case that has conditions as part of the case, then the responsibility to ensure compliance falls to the Executive Director. And so I'll make sure and I do want to give Mr. Alford credit, because it was there, he came up with the idea of what if I take training in Indiana where I am now as one of the conditions. So he's also not a public employee or officer anymore. The university where he is a private one. So he's agreed to take this ethics training, even though it currently doesn't apply to him. Obviously, if he goes to a different university in Indiana that is a public institution, he would. So I will make sure in the compliance that if Indiana has different segments, that the topics most related to the conduct are as what we require to show compliance with the agreement.
So thank you for that response. And once again, I want to credit Mr. Alford for bringing that forward in the agreement. And also, final comment, I'm in support of the agreement, and I also wish you the best of luck in your season number 2. You had a very successful season number 1. And I'm a University of Nevada Wolfpack basketball season ticket holder. So I have to say that on the record. And I also encourage you to work with your father, maybe schedule that game again, but do it properly this time. And good luck, sir.
Thank you very much, sir. I appreciate it.
Any other questions, comments? Okay. All right. I just want to say, Mr. Alford, thank you so much for your cooperation and understanding the seriousness of this. And I appreciate you're also wanting to send a letter to UNR to say, hey, let's make sure people understand the ethics laws and stuff. So I really feel that in the future, if you do enter into a contract with UNR, it will be done properly. And I'll be looking forward to that. So thank you very much. At this time, I will, seeing no other comments or questions from my fellow commissioners, I'll entertain a motion to approve the stipulation in case number 22-038C. Corey Alford as presented, and authorize Commission Council to finalize the stipulations on behalf of the Commission. I have a motion to that effect.
Commissioner Grunwald, I move to accept the terms of the stipulated agreement as presented by the parties and direct Commission Council to finalize it in appropriate form.
All right, thank you. Is there a second to that?
I'll second.
All right. All those in favor say aye.
Aye.
Aye. Opposed? Motion carries. All right, thank you very much. Appreciate it. And now we will move on to item number 6. And I'm going to turn, and this is the hearing on deposit of motions in case number 19-088C regarding Bartolome Ramos, former Public Works Director. current county manager of Lander County, including providing authority to the vice chair, right, of the commission to prepare and issue the order reflecting the commission's decision and other matters relating thereto in consultation with commission counsel. At this time, I'm going to turn it over to Vice Chair Dufferin, who will be the presiding officer in this case. Let me go sit over there. Or stay?
You can stay where you are. Like any member of the public, you're welcome to watch the proceeding. Under NRS 281, Chapter A, you cannot, as a member of the review panel, participate.
Thank you, Chair Wallen. For the record, Chair Wallen and Commissioners Oscarson and Sheets served on the review panel for this case and will not be participating on this item pursuant to NRS 281A.220, Section 4, subsection 4, leaving myself, Vice Chair Dufferin, Commissioners Grunwald, Lowry, Taller, and Yen to participate. It is my understanding, Mr. Is it Ramos?
That works.
Ramos. I want to make sure I get it right. You've received proper notice of the hearing today, obviously, because you're sitting right before us. Let's have the parties identify themselves. Mr. Ramos's counsel.
Rebecca Brew, Lemons, Grundy, and Eisenberg, representing Mr. Ramos.
And for the executive director, Mr. Armstrong, we have Associate Counsel Bassett. All right, so I'm going to just briefly go through how we're going to proceed with this item. So that we have two dispositive motions to be considered by the commission. For presentation purposes, I would like first to have Ms. Bassett present the executive director's motion for summary judgment. And then, is it Brew?
The CH is silent.
Perfect. Ms. Brew, let's hear your opposition to the executive director's motion for summary judgment, and then your presentation on your client's motion for summary judgment. We'll do that second. Thirdly, we'll hear Counsel Bassett's reply and any opposition you might have. And then finally, I would like to hear Ms. Brew's any additional testimony in support of your client's motion. So let's start with Ms. Bassett presenting the executive director's motion for summary judgment.
You guys are gonna get tired of me at the end of this meeting.
And just for the record, all commissioners that are participating in this item today, they have received the materials that are voluminous. We had to use a Dropbox in order to access them. So we have a lot of materials. I'm going to make the assumption we've all read those materials. So let's make our presentation as brief as possible. Thank you.
Good morning, commissioners. It's still morning, yes. Associate Counsel Bassett for the executive director. I'm here this morning regarding the motion for summary judgment regarding two of the alleged violations brought against Mr. Ramos in case number 19-088C. Although the review panel referred alleged violations of 8 ethics laws by Mr. Ramos to the full commission in this matter, the executive director determined that just 2 of these alleged violations were properly brought before the commission on summary judgment today. Those two ethics violations are NRS 281A 420 subsection 1, which is the failure to disclose conflicts of interest, and NRS 281A.400 subsection 3, which is participating as an agent of the government in the negotiation of a contract between the government and any person to whom the public officer or employee has a commitment in a private capacity. So those are the only 2 of the 8 that I'm addressing in my motion today. I know Ms. Brew has other ones in hers. So, but although we are only bringing summary judgment as to 2 of the 8 total alleged violations of the ethics law by Mr. Ramos, we believe we can prove all 8 of the violations at the adjudicatory hearing. And intend to pursue all 8 at the hearing. We're just believe those 2 rise to the level of receiving summary judgment today. So I just want to be clear about that. Under Nevada law, summary judgment should be granted where the pleadings and evidence demonstrate that no genuine issues of material fact exist. I mean, summary judgment is therefore appropriate as to these two ethics law violations because there are no facts that, even if they could be proven at an adjudicatory hearing in this matter, would change the outcome of those violations. The facts that we've gathered so far show that show undisputedly that Mr. Ramos violated these two provisions of the ethics law. In one case, multiple times. So far, in this matter, we've taken a number of depositions and we've exchanged discovery, and that is where as you've seen in your materials, the information we have has come from depositions that we've taken of various individuals, including Mr. Ramos and other Lander County officials. And that is, so that's the process of the place where we're at and what we're relying on at this point. So Mr. Ramos, who's here today, is now the county manager of Lander County, but at all times relevant to these motions was its public works directors in 2018 and 2019. As part of his duties in that position, he was responsible for presenting engineering contracts to the county commission for review and approval. Prior to approximately mid-2018, engineering firms performing work for the county performed their own materials testing and charged the county between 3% and 5% of the total cost of the contract for that service, which is what Keith Westengard, the county manager at that time, testified to in his deposition in this matter. Don Quintana is married to Mr. Ramos' sister, Jody Ramos, and was Jody's registered domestic partner with the state of Nevada in 2018-2019. In approximately mid-2018, she formed her own materials testing company, J&M Materials. Quintana is the owner of J&M, and Jody was listed as an officer of J&M from its formation in 2018 until May 2019, when she was removed from the final of the Nevada Secretary of State. At about the same time that J&M Materials was formed by Quintana, Mr. Ramos had conversations with his supervisor, the then county manager, Mr. Westengard, and proposed that the county begin to subcontract directly for materials testing with a third party. Mr. Ramos proposed to Westengard that the county could save money by directly contracting for these services. There was no disclosure, however, about the timing of this idea coinciding with J&M Materials being formed. After receiving Westengard's approval, Mr. Ramos brought a contract for professional engineering services with Day Engineering to the Lander County Commission for review and approval at the August 9th, 2018 County Commission meeting. This contract contained what I call carve-out provision, providing that rather than Day Engineering doing the materials testing as it had in the past, that obligation would fall to Lander County. And that Lander County would be responsible for materials testing for the duration of the contract. Although Mr. Ramos presented that contract to the county commission, and although that provision was discussed, and the fact that amounts of money were being taken out of the contract that were usually there for that, Mr. Ramos failed to disclose to the commission at that meeting that J&M Materials would be providing the materials testing, or that J&M Materials was owned by Quintana and by his sister. J&M provided the materials testing on behalf of the county under the Day Engineering contract, submitted weekly invoices. Those invoices were reviewed by Mr. Ramos for that work. He reviewed them, he approved them, he signed them. He then submitted them to the county's finance department, and they were placed on commission meetings for approval by commissioners. Again, when they were considered by commissioners at commission meetings, Mr. Ramos never disclosed to the commissions when those invoices from J&M were considered, that J&M was owned by Quintana and by Jody. Also, throughout this entire process, from presenting the idea of using J&M to save money through presenting a contract to the commission, through presenting invoices to the commission. Mr. Ramos never disclosed to his own supervisor, Mr. Westengard, that J&M was owned by Quintana and Jody. Eventually, employees in the finance department brought the relationship between Mr. Ramos and J&M and its owners to Mr. Westengard's attention. Upon finding out that J&M was owned by Quintana and Jody, Westengard sought advice from Lander County's district attorney, who advised that Ramos should not be reviewing invoices or signing invoices. And the process for the review of and approval of those invoices was changed. These facts support a finding that summary judgment should be granted in favor of the executive director as to Mr. Ramos's multiple violations of 281A.420 subsection 1, which prohibits a public employee from acting upon a matter in any way which would be reasonably affected by an employee's commitment in a private capacity to the interest of another person without disclosing information concerning their commitment in a private capacity. I.e., as you know, disclosing their potential conflict of interest. Mr. Ramos does not dispute that he was a public employee or that he had a commitment in a private capacity to Quintana and Jody, who had a pecuniary interest in J&M. The only thing Mr. Ramos disputes is whether he was required to disclose his connection to J&M, and if so, to whom he was required to disclose that connection. First, I would argue the facts support granting summary judgment as to a violation of NRS 281A.420 subsection 1 by Mr. Ramos because he failed to disclose his conflict of interest to his supervisor as required by the ethics law. NRS 281A.4 subsection 1 requires that a public officer or employee who holds an appointed office shall make their disclosure to the supervisory head of the organization. As the director of public works, Mr. Ramos was held an appointed office. Therefore, he was required to disclose his connection to him, which was overseen when he was signing their invoices, when he was presenting contracts, and he was required to disclose that to Keith Westengard, his supervisor. Keith Westengard testified in his deposition that Mr. Ramos never disclosed his connection to the owners and officers of J&M. Rather, Mr. Westengard only became aware of the connection in spring of 2019 when two employees from the finance department brought that connection to his attention. Therefore, summary judgment is proper as to a violation of NRS 281 subsection 1 for this failure, because there are no facts that remain that could be proven, or there are no facts that could change the fact that Mr. Ramos failed to disclose to Mr. Westengard his connection to J&M throughout this process. The facts are that Mr. Westengard was never informed. He found out through the finance department employees, and there aren't any facts that could be brought forward that could change that fact. Second, the undisputed facts also show that summary judgment should be granted as to a second violation of NRS 281A.420 subsection 1 by Mr. Ramos because he also failed to disclose his conflict of interest to the county commission. Prior ethics commission opinions have held that even where a public official is not a member of a public body, they are required to disclose potential conflict of interest when they're involved in a matter that is being considered in a public meeting. Those cases are in re public officer and in re rename, which are in the briefs. In this case, Mr. Ramos was present and actively involved in presenting, discussing, and advocating for the day engineering contract that included the carve-out provision under which he knew and intended J&M would be providing materials testing for the county. The evidence shows that Mr. Ramos was aware and intended that J&M would be performing the materials testing work for the county under the day engineering contract at the time he presented that contract to the county commission. First, he admitted at his deposition that he participated in hiring J&M to perform the materials testing work on behalf of the county under the day engineering contract. Second, when the issue of materials testing costs was raised by a commissioner during the discussion of the day engineering contract at that meeting, the principal of day engineering, Mr. Egaldi, explained that day engineering had removed those costs under the contract because day engineering had been previously providing those services. But now that the county was utilizing another person for that, they reduced the cost, which directly opened the door for Mr. Ramos to explain that who was providing those services. I mean, it directly was being brought up. I don't think there's any room there to say the issue of a different person is providing these services now, the costs are going down. And that was directly on point being brought up when he should have, under the commission's prior precedent, it should have been brought up and disclosed that he had a connection to those people who were going to be providing the services now. Additionally, when Mr. Ramos first presented the idea of the county contracting directly for materials testing services, Mr. Westengard testified at his deposition that the information he was provided by Mr. Ramos was spreadsheets from J&M materials testing. So from day one, the intention was clearly always that J&M was going to be providing these testing services. And in fact, in arguments in these briefs, the argument is there's no one else who could be providing them because J&M is the only local option, there's nobody else. So the intention was always J&M was going to be providing them. So when contracts were being presented to the county commission with these carve out that some third party is going to be providing this testing, it was always J&M who was intended, and Mr. Ramos had an obligation then to disclose, I have a connection to the people who are going to be providing the services, and here's what it is. Even though he's not a member of that public body, the commission's prior precedent requires that. Again, because there are no facts that could be introduced at a hearing that could change that, yet the fact that Mr. Ramos had that obligation and he did not satisfy it, summary judgment should be granted in favor of a finding that Mr. Ramos committed a second violation of NRS 281.8.420 subsection 1 when he failed to disclose his connection to J&M when he was presenting the day engineering contract that contained the carve-out provision that allowed J&M to come in and do the materials testing. Third, the undisputed facts show that Mr. Ramos violated NRS 281.8.421 each time a J&M invoice was presented at a commission meeting. For the same reasons that Mr. Ramos, his failure to disclose his connection to J&M, and as I just discussed with the two previous violations, why he had that obligation. He also had that obligation every time an invoice was presented for payment at a commission meeting. Because Mr. Ramos had signed them, he had reviewed them, approved them, signed them, and then they were presented in a meeting where he was present, and in some instances, they were even challenged by commissioners. And through all those processes, Mr. Ramos again stood silent, never mentioned his connection to them, which is particularly egregious given that he had reviewed them and approved them. And so they came to the commissioners with his approval. And so they were relying on his approval of those invoices when they were in the meeting reviewing and approving them. Again, undisputed evidence is he reviewed them, he approved them, the invoices would be forwarded to the finance department. Mr. Ramos was present at 9 meetings where those invoices were presented to the commissioners. The meeting minutes show no disclosure of his connection to J&M at any of those meetings. Given his connection to J&M, his presence at the meetings, his involvement in hiring J&M to provide the work, and his failure to make a disclosure, I would argue the commission should find that Mr. Ramos committed an additional 9 violations of NRS 281.8.420 subsection 1 when he failed to make those disclosures in those 9 meetings when those invoices were presented for approval. The The commission should also find that summary judgment is appropriate as to Mr. Ramos's violation of NRS 281A.400 subsection 3, which provides that a public employee shall not participate as an agent of government in the negotiation or execution of a contract between the government and the employee or any business entity or person to whom they have a commitment in private capacity. The only element of this violation that Mr. Ramos disputes is whether there's a written contract between Lander County and J&M. However, the existence of a written contract is not actually required for a violation of this ethics violation. So the statute prohibits either the negotiation or execution of a contract. And that's the first issue. And the second is that the statute does not require that the contract at issue be a written contract. The fact that Mr. Ramos negotiated a contract on behalf of Lander County with a person to whom he had a commitment in a private capacity. Mr. Ramos testified at his deposition that he met with Ms. Quintana and through her hired J&M Materials to provide materials testing services for Lander County. He testified to that at his deposition. Ms. Quintana likewise testified at her deposition that she participated in discussions with Mr. Ramos regarding J&M Materials providing services to Lander County. The undisputed evidence therefore shows that Mr. Ramos negotiated on behalf of and between Lander County and Ms. Quintana, to whom he has a commitment in a private capacity regarding J&M Materials, in which Ms. Quintana has pecuniary interest. To violate NRS 281-400 subsection 3 requires negotiation of a contract. The negotiation between Ms. Quintana and Mr. Ramos was that J&M Materials would come in, provide the scope of work would be materials testing under whatever the main contract was, and the payment, which Ms. Quintana was really clear in her deposition testimony, was she was going to come in and charge 3%, which she believed was lower than what was being charged, and currently, and that was what she was paid. Under any contract law, a contract has offer acceptance to be in the minds. And I think there's enough of the essential terms of our contract for that to be like a negotiation of an actual contract. And then they actually moved forward and worked under that contract for a long time until they entered into a one-year contract later with the commission when this ethics violation was filed, or ethics complaint was filed. But so both, although trying to avoid discussing having a contract or otherwise, both Ms. Quintana and Mr. Ramos testified at their depositions that they engaged in conversations about Lander County about J&M performing materials testing for Lander County, what the cost of that would be, and that materials testing would be performed under the overall scope of whatever the main engineering contract was that like in the engineering, whatever the main engineering contract scope of the engineering contract was that was being, the material system was being provided under. So that was the scope of the work. The payment was 3% of whatever that total contract was. The terms of the payment were weekly invoices. And they negotiated that between the two of them, Mr. Ramos on behalf of Lander County and Ms. Quintana, as someone he had a commitment in a private capacity to. Nothing in the statute says that had to have been in a written contract, and they very carefully did not enter into a written contract. And Ms. Quintana stated she doesn't enter into written contracts, and that's her standard practice. She has these oral agreements, and for what she does, I guess it can make sense because she can operate under the terms of the main engineering contract, which contains the scope of work and which contains the price. And she's 3% of that price, and she does the materials testing based on that scope of work. But it doesn't relieve an ethics violation based on negotiating between two related parties. You can't get around that just because you don't sign a contract. They still negotiated between themselves an agreement, a contract for J&M to provide certain services to the county under certain terms. And they both testified to the fact that they're the ones who made that agreement. And then that agreement was executed, whether it was in writing or not. And the essential terms were there. The terms were contained in the day engineering contract, the scope, the 3% of the overall price. And then they agreed how it would be paid, which was weekly invoices. And then that is in fact what happened. And Mr. Ramos approved them. So I do believe the fact of a written contract is not necessary, and there was still negotiation and really execution of contract. I would argue that, in conclusion, I would argue that summary judgment should be granted overall. If you count up what I've asked for, it's 12 violations of the ethics law, 11 are under NRS 281A.421 and 1 under NRS 281A.403. Right. You have a confused look.
You said 421, can you?
420 subsection 1.
Thank you.
Sorry. And 1 under NRS 281A.400 subsection 3.
Thank you, Ms. Bassett. Ms. Brew.
Thank you, Commissioner. And for 20 years, I've been doing work representing public entity clients. And I would say this is the first time I've actually been in front of you all. So it's very interesting and and I do appreciate it, not at the price to my client, but anyway, Mr. Ramos is from the time that he received this charge, and he was flabbergasted. He was speechless. Mr. Ramos was born and raised in Battle Mountain, Austin area, one of 5, I think, 8 kids, one of 7 siblings, all of them live in that area, as does his wife, as does Ms. Quintana. These people have all lived in that very small community forever. And because of that, there are certain assumptions that we all make, and we think people know this and people know that, and it's just a natural, I think, human nature that we assume what somebody else may know. And from the beginning of this, Mr. Ramos said everyone knew that Jody and Nettie were an item. Everyone knew that. How could they not know it? And so when he and I were working through this, and I said, well, did you ever talk to anybody about it? And he said, well, no, no, we all know each other. It was never a topic of discussion that they were an item. So when you look at the depositions, for instance, so Mr. Herrera, Ted Herrera, who was the district attorney in Lander County, and Keith Westengard, who was the then county manager, were interviewed by Mr. Terry. And then because I needed to know what they were going to testify to, they were then deposed. There was clearly, in my mind, some confusion about, again, part of this, what do people know and not know? And Mr. Westengard, and I could have these mixed up, whether it was Mr. Herrera or Mr. Westengard. Some said, well, I knew Jody was Bert's sister, but I didn't know Jody was with Nettie, and I didn't know that J&M was Nettie and Jody, all kinds of variations of that. So that's just illustrative of things that people assume, and turns out maybe they didn't know. So with that, and so, Mr. Ramos grew up there, as did his family. Nettie Quintana had been working in the mining industry for a very long time, doing testing and these kinds of services. And after I think she said she'd been doing it for 18 or 20 years, got tired of it and said, I can start my own company. And so she did. And in her deposition, she testified that it was slow in the beginning, but that she just went out to everybody in the neighborhood and was handing out, she was doing soliciting in Humboldt County, in Winnemucca, and several other places in addition to Lander. Ms. Quintana testified in her deposition that she never talked to Bert Ramos about doing Lander County work. And Mr. Ramos has also testified. So when Ms. Bassett, or when the executive director says in their argument, and they cite to Nettie Quintana's deposition at pages 12 through 16, she says the terms of J&M services were negotiated between Quintana and Ramos. If you read pages 12 through 16, there is nothing in that deposition or anywhere else that there were any negotiations between Mr. Ramos and Ms. Quintana. Ms. Quintana said when she made this decision that she was going to take a swing at this, she started submitting her paperwork everywhere, including in Lander County. She had been doing some work for Martinez, for AM, and for Day Engineering. And in fact, Mr. Martinez testified when he found out that there was this local person, he tried to hire her. And she said, no, I'm going to open my own business, but hey, I'd love to do work for you. So, and so she went through the process. But, and so as far as there being any kind of negotiations, there were no negotiations. She filled out the paperwork that she needed to fill out to be able to do business with the county. She set the price based on industry standards. And so that I wanted to address one of that is in what Ms. Bassett calls, or what the executive director calls, an undisputed fact. And we do dispute that there were any negotiations between Ms. Quintana and Mr. Ramos. There is also no evidence that anyone considered those invoices to be a contract. That may be the executive director's legal interpretation, but as we point out, as we all learned long before we went to law school or anyplace else, a contract is an offer acceptance and consideration and a meeting of the minds. Ms. Quintana offered the same conditions to do work for everyone. That I'm going to do this cheaper than if you were paying me, or if you were paying for any of the engineering firms to do this in-house. She specifically testified that there was no contract with any of her clients. Interesting to me that in Ms. Bassett's argument, she says they very carefully, that it was intentional that there was no contract. To me, that speaks clearly of what the intent was. I call it a good old-fashioned handshake deal, that she's out there. We don't see that much anymore, but she's out there doing business on these contracts that are tens of thousands of dollars on a handshake with every single one of her customers, not just Lander County. So I wanted to comment on those statements that were in the motion. As far as and there's a lot of overflow, just so you know, between my motion and Ms. Bassett's motion. And so some of this, so the meat of my arguments will be when I talk to you about my motion for summary judgment. But just a couple of things I wanted to touch on. Ms. Bassett says that the only issue there is regarding 281A 400 paren 3 is that whether this business arrangement amounted to a contract. there was more. If you go back and read my motion, there was much more to that. Yes, we argue that there was no contract. And so when you look at the terms of, at the language of that statute, that there was no contract, so that in and of itself exonerates Mr. Ramos. But, you know, as I said a minute ago, one thing that we know for sure is that Ms. Quintana did not believe there was a contract. She testified she had no contracts with any of her customers. If one or both of them intentionally did not enter into a contract, I would argue it does not exist. And there was no negotiation. Contrary to what the executive director argues in the reply, Mr. Ramos' argument was more than the fact that no contract existed. One of the provisions in 281A 403 also has a component regarding participation in a negotiation process. As Mr. Ramos argued as we've argued in our motion, there was no evidence that he talked to any commissioner or anyone else. He testified that there were no commissioners that he talked to about this contract or about this arrangement. Anyone who had the final decision-making authority, whether it was payment of the invoices or whether it was approving a contract for services. And I would ask you to look again at the Boggs McDonald opinion that I cited in my brief. And that in that case, Ms. Boggs McDonald was exonerated. And that issue was not addressed in the executive director's reply to my opposition. Regarding NRS 281-421, if you don't mind, what I'd like to do is, because the crux of my argument, the meat of my argument is in my motion for summary judgment. So I would just incorporate that by reference, if I may, to apply also to our response to the executive director's motion.
Sure.
Thank you. No. No. So I want to start as I told you briefly at the beginning a few minutes ago. Mr. Ramos, born and raised in the area, as well as Ms. Quintana and the rest of the Ramos family. In 2009, Mr. Ramos went to work in Road and Bridge, and then became the Public Works Director in June of 2015. In 2018 is when Ms. Quintana formed J&M Testing. And the invoices for those start in April of 2018. But we believe, and if this were to go to an adjudicatory hearing, that the testimony from Ms. Quintana will be that she had actually started work and that the paperwork had been completed, but there were some errors that had been made prior to the date of those Secretary of State documents. I think those were in July of 2018 is what we have of record. So I didn't want anybody to think that because the first invoice from J&M was in April of 2018, that she was somehow working without a license. And I don't have, So in March, she starts doing work. J&M starts doing work. In July, there was a Secretary of State list of officers. And then in May, I'm sorry, I've got these dates backwards. Anyway, then Ms. Ramos was taken off of the Secretary of State list of officers. A very important fact in this, and one of the very first things when I sat down with Mr. Ramos for a very long time, walking through this step by step, as he says, How could the county have not known that we were related because High Forgeron drew up the papers? And Mr. Forgeron, who's been around for a very long time, is the deputy district attorney in Lander County, has functioned in that capacity, in different capacities for a long time, and also been in private practice. So in his capacity, at the same time as he's the district attorney, the assistant district attorney for Lander County, he drew up these Secretary of State papers for J&M testing, and he's the one who made the correction and had Ms. Ramos removed. So in Mr. Ramos' mind, he was the district attorney. If he knows about this relationship, he knows me, he knows her, he knows that this is a company that's being formed to do, and that it would be doing business with Lander County. Why on earth would he have not told me that I needed to do something about this? And remains part of his frustration in this. So yes, as Ms. Bassett said, at some point there were 2 employees out of the finance department who came to Mr. Westengard and said, hey, did you know that Jody Ramos is Bert Ramos' sister and she's part of J&M? And Mr. Westengard testified that he did not know that he had not connected all of those dots. And he immediately went to Mr. Herrera. As you all said, it's voluminous, what we have filed. There's a lot there to read. One of the important pieces in my mind and in Mr. Ramos' mind is the genesis of this. Now, as I said, I've been doing work in front of the commission for 20 plus years, and I understand that oftentimes the story is kind of the same. When I say to you, this is a vendetta by Judy Allen against Mr. Ramos, that she's going to use scorched earth to do whatever she can to take him off of the face of the earth, including there were criminal issues there where she tried to run him off of the road. And so this was all sort of viewed by Mr. Ramos and everybody else in that town as that's just Judy Allen on her campaign to do whatever she can. And that doesn't, and I understand that many of the complaints that I respond to come from a disgruntled ex-employee, a disgruntled ex-wife, as you all, you know this better than me, that these aren't, necessarily born out of somebody who doesn't have an axe to grind. But that was sort of the paradigm for all of this, was that it was just Judy Allen doing what she did. And the history that I won't repeat in detail, though, was that when Mr. Ramos worked side by side with Ms. Allen's boyfriend, Donnie Negro, they decided to create a public works director position. They both applied. Mr. Ramos got the job and Mr. Negro did not get the job, and then went on to be fired by Mr. Westengard. Ms. Allen gets elected to the county commissioners, and then tried to use her influence to get the county to settle the lawsuit that Mr. Negro brought for wrongful termination, which resulted in an ethics complaint brought before you all a few years ago. This was just another day in the life of Judy Allen, and for Bert Ramos and other commissioners and folks in Lander County, another day in the life with Judy Allen. So when we're looking at 281A 401, it was in my mind, the language that we focused on was that the public officer shall not seek favor or employment engagement for himself or someone who he has a commitment in a private capacity, my yellow highlights, which would tend improperly to influence a reasonable person in the public officer's or employee's position to depart from the faithful and impartial discharge of the public officers or employees' public duties. There is no dispute that J&M, what they were doing constitutes engagement as contemplated by this statute. Of course, that's his sister and her significant other. The dispute is whether that engagement would properly tend to influence a reasonable person, Mr. Ramos, to depart from his faithful, from the faithful and impartial discharge of his public duties. Or, as the executive director put in their opposition, is there a genuine issue of material fact that Mr. Ramos sought and accepted on behalf of his sister and her significant other, something that would, to someone to whom he has a commitment in a private capacity that would tend to improperly to influence a reasonable person in his position to depart from the faithful, impartial discharge of his public duties as the Director of Public Works. So what were Mr. Ramos' duties? His duties were to act in the best interest of Lander County when he was carrying out those duties as the Public Works Director. He had been the Public Works Director since mid-2015. In 2018, J&M was formed, and J&M began doing work for many entities, both public and private, including Lander County. When J&M was no longer doing work for Lander County as a subcontractor under another engineering firm, they began to generate invoices to Lander County for the work that they were doing directly. And those had to be signed off according to policies in Lander County. Those invoices had to be reviewed and signed off by the department head. That's Mr. Ramos. That process was followed religiously in Lander County, in the Public Works Department, and at any place else where there was a department head. There was not, in all of this, there was not a single invoice. There was no allegation of a single invoice that was not brought to the BOCC for review and approval. And I would suggest to you that he would have departed from his faithful and impartial discharge of his public duties if he had not used J&M for Lander County Public Works projects for which they were qualified. Mr. Martinez testified, he in his declaration that was attached to our motion, clarified some things that, I think there was a question or a point made about, do you use anybody else besides J&M on Lander County projects? And he said, absolutely, I do. In large part because there are projects that J&M is not qualified to do. And he explained it to me in terms that went over my head to understand, but there has to be labs available and all kinds of things that depending on the project, you have to maybe have certain certifications that J&M did not have. So he explained that in his declaration. Why and what else do we know about this arrangement that came to be that J&M was doing work for Lander County? We know that there were no other materials testing services in Lander County until J&M started operating there. And he testified, Mr. Martinez said, and Lander County, Mr. Ramos testified that they were saving tens of thousands of dollars, if not. I think in his presentation in May of 2019, where on the public record he talked about his relationship with his sister. I think that number by that point was about $260,000 or something. It doesn't matter, but it's a lot of money that was being saved by using a local. We know that Lander County had a buy local policy. And we know, according to Mr. Martinez, Mr. Westengard, Mr. Ramos, and Mr. Montana, that multiple people said that the county was saving a whole lot of money. I talked to you in my brief about the Rudder complaint, and I think that the Rudder complaint, an opinion that was issued by by you all in 06, in opinion number 06-57, I think it has some good takeaways that I think are helpful to Mr. Ramos, and I think they are close enough on point that they should be persuasive to you. And in that case, Ms. Rudder was the public guardian. She was charged, as part of that, she was charged with overlooking or overseeing the Creech estate. The Creech estate needed to have stuff put into storage. It needed to have the stuff moved from the house. And there was no storage facility in Caliani, but Ms. Rudder happened to own a facility about 50 miles away. She stored the items in her storage facility. She hired her nephew and his wife to pick up the property. There was no evidence in that case of any, and these are the findings that the commission made when they found her that the charges were not supported. There was no evidence of anyone else in Lincoln County that provided those services. Also interesting little twist on this that first was a little caught my eye, and then I was okay with it. It talked about that she had asked the district attorney if it was okay, and he said yes, but later testified that he thought she meant she was storing it in her own garage, not for a fee, but that and it turns out, and he didn't realize that it was a commercial storage facility. And even then, the commission found that there was no violation of the statute, and the commission considered that she could not find a local facility and her rates were reasonable. It's a little bit comparable to our situation, because in Mr. Herrera's deposition, and I can't tell you exactly what the question was, but I think it had to do with whether Mr. Herrera, would his testimony be any different? Because he stands by the position that Mr. Ramos did nothing wrong, and that all Mr. Ramos had to do was stop signing those invoices, and that was okay. He was asked if he had known, because he testified that he did not know about the relationship between J&M, Ms. Ramos, and Ms. Quintana. And I think Ms. Bassett asked him in his deposition, had you known that, would your answer be different? And he said yes. So the idea, it's comparable to the Rudder case, where the district attorney likewise said, well, yeah, I didn't know that they were going to charge a fee. And so I would ask you to take note of that. This situation is similar with J&M. There was no local service, and J&M was saved the county a whole lot of money. The executive director argues that Mr. Ramos hid his relationship from everyone around him. That's what is, that's the language from the brief. There is no dispute that Mr. Ramos did not make a formal disclosure in a formal sense. He does not dispute that. His discussion at the May 9th, 2019 meeting was what I would call serendipitous part of his report, his staff report in the normal course of a county commission meeting, and he was going over the savings, and he was talking about answering his phone at 2:00 in the morning and everybody calling him and how hard he was working for the county. And he acknowledged as part of that conversation that Judy Allen was complaining to anyone who would listen. And he stated, I have nothing to hide. Everyone knows my sister is dating Nettie Quintana. And then there was a little bit of a funny about, well, I think they're dating. I don't know. I don't understand all of this. Anyway, he said he did not make that statement because someone told him he should disclose. That just came out of his mouth because, as I say, this was part of the normal life with Judy Allen. He was reporting to the commissioners about all the money he was saving, including the money he saved on those testing services. I'll talk a little bit more about this when I address the disclosure statute, but the bottom line is that Mr. Ramos did not know he should disclose anything. You heard, so as you know, at some point, Mr. Westengard goes to Mr. Herrera and says, did you know that this is, Bert's sister? And they say, well, oh, and Mr. Herrera says, well, okay, yeah, he probably, let's just change that. Everything's good, everything's cool. Keith, you need to start signing off on those invoices. End of discussion. Never a word to Mr. Ramos about it from the district attorney. Mr. Westengard just says, Ted says it's all fine. I'm going to, start reviewing these and everything's good. So even when the district attorney advised that Mr. Ramos should no longer be signing off on the J&M invoices, he never said a word to Mr. Ramos about a potential duty to disclose. I will tell you to this day, the district attorney has not ever said a word to Mr. Ramos or anyone else that he had some kind of an obligation or he should be disclosing. And it wasn't until he and I have worked through this that he now understands that obligation and why it is what it is. Turning now to 402, 400(2), it holds in pertinent part that he shall not use his position.
Can I interrupt you real quick?
Yes.
How much longer do you think you're gonna have?
Well,
on this part of your presentation?
I will hurry. If I can have 10 or 15 minutes, if
I'm
that's,
gonna take a break after that.
Okay.
Go ahead, please.
okay, thank you. What that 400(2) says is that Mr. Ramos shall not use his position as the Public Works Director to get unwarranted privileges for his sister Jody Ramos. Unwarranted means without justification or adequate reason. The statute, the executive director argues in their opposition that if he used his position to do that, that equals unwarranted. And that is not what the statute says. The statute says a public employee may not use his or her position to get unwarranted privileges. The analysis for you all is whether Mr. Ramos' conduct was unwarranted, and I would argue that it was not unwarranted. That's discussed in the Wood opinion, and it talks about, are there colorable reasons to support why someone did what they did. Mr. Ramos had colorable reasons for doing the work, saving the money and supporting and the buy local policy. He did not have a final say in the award of the contracts or the invoices that were to be paid. Mr. Ramos' duties included making sure the county got the best bang for its buck. That was his job. He was supervised. He had a supervisor who, had the county manager, Keith Westengard, who had has some responsibility for this. He supplied the invoices to the commissioners for review, I would repeat that Mr. Ramos had no idea that this situation could violate the ethics law. He had no direction from anyone until the DA advised that Mr. Westengard should sign off, and he then immediately stopped being part of the process involving the J&M work. And even then, the DA has never addressed this. It's interesting to me this morning being here, listening to the presentation on the Alford case, because what I found myself doing was making notes of the mitigation that Ms. Bassett was arguing. And I understand that these are not the same cases at all, but the words are the same. She said it was well known about the relationship between Mr. Alford and his son. It was well known, the relationship between Mr. Ramos and his sister and Nettie Quintana and J&M. just recently, in the last couple days, I have found out that in a recent conversation that Mr. Ramos had with former members or current other members of the county commissioners, they said, we all knew that was your sister. Sean Baker, who had been the chair at the time, Doug, I don't remember his last name, who was Mills, who was the vice chair, were in this conversation. We knew. She also said that it was not hidden. The relationship was not hidden. Mr. Ramos did not hide his relationship. She mentions that unlike Mr. Ramos, that Mr. Alford did not self-correct and Mr. Ramos did. She mentioned that there had been no training and no advice for Mr. Alford, the Mr. Alfords, and same with Mr. Ramos. As soon as Mr. Herrera advised, he stopped. Moving on to 400. Paren 3, and that's the statute that says Mr. Ramos is prohibited from participating in the negotiation of a contract between Lander County and J&M. As we already said, in our opinion, there was no contract between J&M and Lander County until the one that was in January of 2020 that was in an open meeting and was adopted was approved by the county commission. The testimony is consistent regarding this. Mr. Ramos testified he didn't participate in procuring the work. Ms. Quintana testified that Mr. Ramos did not participate or assist in any way. There was no contract, and Mr. Ramos played no role in that January 2020 contract. Mr. Westengard testified that the engineering contractor made the sole decisions about what testing services were needed, not Bert Ramos. The scope of work, as Ms. Bassett pointed out, was in the contract with the engineer. Mr. Herrera testified that he asked Mr. Martinez if Mr. Ramos pressured him into using J&M, and Mr. Martinez testified no. Mr. Martinez testified in his affidavit there was no pressure to use J&M testing. I probably have maybe 5 or 10 minutes left, and so it's your whatever.
Let's get her done.
Okay.
Quick, please.
Okay, moving on now to 281A 421, which is the disclosure statute. Abstention is not an issue here. He was not a member. Mr. Ramos was not a member of the voting board, and prior to that, prior to the contract, there was his only involvement were along with his duties in procuring getting the best bang for the buck as he can for Lander County. As part of the staff report, as I told you, he made a public disclosure, and I say that I use that loosely because it was just a comment. The language was Mr. Ramos stated just precisely, and then on another one. So I have our inspection services. We used to get a flat 5% rate from our engineer, of whatever the job was. And if you added a change order to it, then you got 5. They took the 5% of that, and that's materials and everything else included. Well, I took that away and we went with a local, and I know it's caused some stir because my sister is involved and it's a smaller community. I have nothing to hide from anybody, but my sister and Nettie are dating. Everybody knows. Or I'm not sure if they are, but so anyway, and I've always went with local business. It's been something that I've done since I got hired in Austin. My brother-in-law ran the Napa. We always did business with them. We get fair pricing. And so I know that it's caused some concern, especially with one commissioner. So I wanted to point out some cost savings in the project since they've been with us. The minute that there were any questionable issues about this relationship, Mr. Ramos withdrew from the participation. At best, as I suggested, there was confusion about the relationship. Mr. Ramos received no advice from anyone to disclose anything, and yet still this information came in that May 9, 2019 meeting. He followed every bit of advice that Mr. Herrera gave him. He got no other guidance from anyone, and he had no clue that an issue existed. All he knew was that Judy Allen was doing what she does. Mr. Ramos, like everyone else on the county commission, gave no thought to her continued harassment and rants. I am aware that a significant goal, so in my 20 years, I've seen a lot of change in philosophy over the years from this commission, and it used to be, there was a period of time when it was sort of a hang 'em in the public square kind of an approach. And that has changed a lot over the years, and I have appreciated that on behalf of my clients, where it's become one of education and of, sharing. And so make sure that these things don't happen, and especially in our rural counties, there is so very little support. And Mr. Ramos is also familiar with that goal. He's acutely aware of the risks of making assumptions now. And all he knew was that when J&M was able to provide cheaper services and support the buy local, he had an obligation to facilitate that. Mr. Herrera did not advise him. I would say that I would tell you we believe that his conduct did not violate 281A 421. Moving on to 420(3), which says that shall not vote upon or advocate for the passage or failure, but may otherwise participate in the consideration of a matter with the respect to which the independence of judgment would be materially affected. We would reiterate our arguments related to section 1 above. Mr. Ramos did not vote upon or advocate if by performing his duties and obligations as a department head to sign off on all the invoices was a violation. He certainly did not know it, and he didn't get any help. I want to talk real briefly, I'm almost done, about exceptions to the ethics laws. 281A 170 defines the willful violation. I don't need to read this to you. I bet you all know this by heart. So I'm going to skip that. And I want to talk about the advice of counsel piece. Mr. Ramos, and I've said this a lot, that he did not seek Mr. Herrera's counsel because he didn't know. It never occurred to him that he should do that. He knew Mr. Forgeron and assisted J&M. My biggest fear as a lawyer is always when I don't know what I don't know. That's when I scare myself. I don't know what I don't know, because if I know I don't know it, then I can go get help. And in my view, this was the same situation that Mr. Ramos, in retrospect, found himself. Mr. Ramos didn't know what he didn't know. It was not his fault that he did not know to raise this issue. He knew if there was a question, and Mr. Ramos should have continued to disclose after he stopped reviewing the J&M invoices, that was never advice that he received from Mr. Herrera. And that goes to Ms. Bassett's argument about 9 violations, because in subsequent meetings, and that's the giant binder that you all have of all of those public meetings, where I assume her point is that here was discussion of all of these contracts where potentially there were testing services involved, and he never disclosed. It never occurred to him to this day that he should, if in fact he should. 281A 430(4) holds in part, a public officer may bid on or enter into a contract with an agency if the contracting price is controlled by rules of open competitive, or for solicitation are not employed as a result of the applicability of NRS 332.112. The sources of supply are limited. The public officer or employee has not taken part in developing the contract plans, and the public officer will not be personally involved in opening, considering the offers. If a public officer who is authorized to bid on or enter into contract with an agency pursuant to this subsection is a member of the governing body, he shall disclose that. Mr. Ramos is not a member of the governing body. This work was not subject to a competitive bid process. Mr. Ramos did not take part in developing the contract plans. There were no other suppliers locally. And I would again refer you back to the Rudder case, because I think it is very, very on point. Look at the involvement of the EDA. Based on those factors, it is Mr. Ramos' sincere belief that he was doing what he was required to do. And we would ask that the commission grant our summary judgment motion in its entirety or otherwise as you deem appropriate. Thank you.
Thank you for speeding that up. It's currently it is 11:25. I want to take a 10-minute break, and then we'll have each party one more shot at a reply. I'm going to ask for questions from the commission, and I'd like to have a motion on this item to be concluded. So let's reconvene at
before the commission. So I just want to put that formally on the record. Appreciate your representations on it. That's likely why the review panel dismissed it, Ms. Brew. So at that point in time, that was not a case that was referred to the commission as a whole.
And I apologize for even using the time. I promised that I had looked at this thing over and over, and I thought that I was so afraid that I was going to assume that one maybe got dismissed when it didn't. And so I apologize, but thank you.
Yeah, just for the record, so that now we can just focus on the remaining matters before the commission.
Thank you. So we have 2 replies. I'm going to limit those to 10 minutes each. So let's go with Ms. Bassett.
All right, get to it. First, I'd just like to address this issue of the requester. And Mr. Ramos' counsel's argument regarding Judy Allen's requester in this matter. As the commission knows, the motive or the reason the requesters filed an ethics complaint is not properly considered when considering whether a subject has violated an ethics law. It's really an irrelevant issue. Either there's a violation of the ethics law, there's not. Why someone might have filed an ethics complaint and what their motive was, or why they're bringing that to the Ethics Commission's attention has nothing to do with whether there's a violation of the law or not. And so I would ask that the commission not take that into consideration, as it's not a proper thing for the commission to consider. Likewise, any benefit to the county, money savings or things of that nature are also not proper arguments as to whether Mr. Ramos violated an ethics law or not. First, there isn't any proper evidence before this commission that you could even consider as to whether that's a factual argument or not. There's sort of competing testimony on the record as to what the county was paying prior to J&M Materials. Mr. Westengard testified it was between 3% and 5%, and J&M charges 3%. All the evidence of what the savings is comes from J&M and interested parties. So I would argue there isn't really solid evidence as to whether the county is saving as much money as is being represented. But regardless, it's irrelevant because it doesn't matter. That's not a factor as to whether there's an ethics violation. All of that benefit could have been accrued to the county without an ethics violation. So the fact of the savings is not like if ethics violation didn't have to occur, there could be savings to the county. The savings to the county could have occurred regardless of an ethics violation. All of this could have happened while following all of the ethics rules. So I think any argument regarding savings to the county is irrelevant to whether there was an ethics violation. You know, there's a lot of argument by Ms. Brew about like not knowing what you don't know, and as sort of a defense to to an ethics violation, but as this commission is well aware, well, there are sort of two buckets of defense. It's not knowing what you don't know, and also everyone knows. So the not knowing what you don't know, I mean, not being aware of the ethics obligations, as this commission knows, that is not a defense to an ethics violation whatsoever. When you are a public employee or a public officer, you yourself have an obligation to know what the ethics laws are and to follow them. So Mr. Ramos, at the time that he violated these ethics provisions, had an obligation to know what they were and to follow them. It is not a defense to an ethics violation that he did not know what his obligations were. Secondarily, the argument that he assumed everybody knew. I mean, number one, our commission precedent is clear. You can't make that assumption. In fact, even if he had disclosed at one of these 9 meetings, he would have disclosed at every meeting. It's not enough that you think people know or that people do know, or even that you disclose once. You've disclosed over and over and over again, and it's not a defense to that you think people know, or you assume people know, or even that you're sure that people know. So it may be a mitigating factor, as we heard in the argument in previous case stipulations before this, that it might be a mitigating factor, but it's certainly not a defense. And in fact, the evidence here is that people did not know. In fact, his boss, Mr. Westengard, did not know. He didn't know over a long period of time that J&M was owned by Mr. Ramos, the sister, and her partner. And obviously, many of the commissioners did not know, because Ms. Allen, who he says would have loved to have, turned him in earlier, didn't know until much later. So it's clear a lot of people did not know about this relationship, and so it's neither factually correct nor is it an actual defense. This argument here is that he admits he didn't make a disclosure because he didn't know he should disclose. Well, that goes to the fact that, yes, there was a violation. There was a disclosure that was required. The disclosure had to be made. The disclosures weren't made. That's a violation of the ethics law. The argument that follows goes to willful versus non-willful, whether it's a willful violation or a non-willful violation. And so I would argue these are violations. The disclosure was required. He was required to disclose it to his supervisor. He didn't do that. All these times he stood up in front of the commission and were presenting these things, was required to disclose. And whether whether he had the training or whether he knew or didn't know he should do it, or what, these go to whether it's a willful violation or a non-willful violation. They don't go to whether there is a violation. They might be relevant to a willful or non-willful or settling, like in the last case, but they don't go to whether there's in fact a violation. As to the arguments about NRS 281A 400 subsections 1 and 2, and whether he had whether it was an unwarranted benefit, or whether it would cost him to improperly influence a reasonable person. I think our precedent is very clear on those things. Those things are very fact dependent. We found under 400 subsection 1 something as small as annual movie passes, or the nominal cost of enough to influence someone, to improperly influence a reasonable person. I think hundreds of thousands of dollars worth of public works contracts to a family member, I think certainly rises to our precedent has held to be enough under that statute. I don't think they've shown undisputed facts that would be enough to go out summary judgment.
2 minutes.
As to the unwarranted benefit, this commission has held in the past that a public officer employee using their specialized knowledge to information they know as a result of their employment is to benefit someone they owe a commitment to is enough to violate that statute. And here clearly that's the case. He has the inside knowledge of what the county needs, how to work that process. He talks to his supervisor. They changed the whole process for his sister's company, basically creating a new pathway for that company to have worked with the county directly. I don't think there's undisputed facts that would allow that to go on summary judgment at this point. Am I done? So I think I would request that it be denied.
Thank you. I don't mean to rush people, but I'm just trying to make sure that each party has equal amounts of time. And once again, as I stated earlier, all the commissioners have all these materials, so I'm just trying to expedite this item. So, Ms. Brew, you're up next.
Thank you. I'll be brief. In response to Ms. Bassett's comment about the money, that there is no evidence about how much was saved or whether there was a savings or not, it was agreed, the evidence is consistent that it was agreed that there was some money savings. And yes, that we did not get into the weeds about confirming how much it was. What matters is that Mr. Ramos believed that it was going to create a significant savings for Lander County. And that goes to the unwarranted piece of this and part of the logic about it. And I see this issue, well, it is completely separate from the issue about disclosure. If you want to talk about, okay, we didn't disclose, well, let's talk about that under the statute, the disclosure statute, not under whether 400 parentu has been violated or not. The only other comment I would make is that my interpretation of what Ms. Bassett has said is that the executive director is suggesting that J&M should not do work flat out because Jody Ramos is a partner of Nettie Quintana. And that's not the intent of this statute. It was justified because of the cost, partly because of the cost savings, partly because of the buy local. And this was, if you look at the language in one of those later in the January 2020 contract, Judy Allen said, well, I don't think that J&M should get to do work for Lander County because Jody Ramos is Bert Ramos' sister. That's not the law. And so, and what I hear Ms. Bassett suggesting is that the mere fact that J&M is doing work for Lander County violates the statute. And I don't believe that is, that's the analysis. With that, unless you have any questions, thank you for listening.
I would like a chance to clarify. If I may.
Quickly, please.
Yeah, I definitely am not saying at all what Ms. Brew is saying. I am saying had Mr. Ramos taken himself out of the process, J&M could have worked for the county without violating any ethics laws. The problem is Mr. Ramos's insertion of himself into this process with his sister's company. It's not J&M working for the county whatsoever. The problem is him reviewing the invoices, him negotiating the contract, him not properly disclosing, him not following the ethics rules. It's not J&M working for the county whatsoever. J&M certainly didn't work for the county. There's a process that had to be followed appropriately, and it wasn't followed. J&M still works for the county now, and as I understand it.
Okay, thanks for that clarification. Thank you for both of your presentations, and now I'd like to have any questions from the commissioners.
I have a question.
I see Commissioner Yan first. I'm sorry, Commissioner Grunwald. It's probably because she's right in front of me. Go ahead, Commissioner Yan.
I'll be quick, Commissioner Grunwald. Thank you, Vice Chair Dufferin. I have questions related to the 400 subsection 2 and 400 subsection 3. So my first one for 400 subsection 2 is for the associate counsel, Bassett. For the statute, it specifically says if it's unwarranted or without justification, and it describes what, defines what that means. So is the position of the executive director that money savings and buying local is not sufficient justification or warranting for the contract?
No, but our position is that's the fact-dependent analysis that isn't appropriate for summary judgment.
So is it a disputed fact then that, are you saying that it's a disputed fact as to whether Lander County had to buy local policy, and or that it's a disputed fact that it going with J&M created money savings? What's the disputed fact?
I would say there is a disputed fact as to whether it created a money savings, yes. The buy local policy is also not an undisputed fact. That was explored in deposition, and at one point, people said there was not a buy local policy that showed up after discovery closed. So those are disputed facts. They're not disputed things, either of them. Again, they haven't been shown to be undisputed. So in this instance, they're not undisputed. So I don't believe summary judgment is appropriate in this instance for that reason to begin with. But yeah, well, so sticking to this instance, yes, I don't think they're undisputed facts, either of those facts.
Okay.
That would merit summary judgment.
Okay, thank you. And then related to 400 subsection 3, I read the deposition excerpts that were provided for both parties for the exhibits to the motion, to the two motions for summary judgment, both Ramos and Quintana. And my question is, in Ramos, he does say he admits that he did meet with Ms. Quintana about the Lander County work. And Ms. Quintana also testified saying, were they talking about the day contract, or were they talking about the 16 various invoice work?
You're asking yourself?
Whoever can answer that question.
The associate counsel Bassett, it's a bit hard to tell because there was a great reluctance in the deposition for them to answer questions about any agreement for J&M to work for Lander County at all. As best I have is that there was generally an agreement that for J&M to go out and do work for Lander County, and that Mr. Ramos and Ms. Quintana were the ones who met and made that agreement to go there and work. And the first time that occurred was under the data engineering contract.
Now,
May I respond?
yes, please.
My recollection of the testimony was that everyone cooperated and that there was no hesitation for anybody to talk about it. My understanding of the testimony was that Ms. Quintana said there was no conversation between she and Mr. Ramos prior to J&M being approved to be a contractor for the county. That after that, Mr. Westengard testified in his deposition that after that approval happened, that he and Mr. Ramos then approached Ms. Quintana and said, hey, we've got a project now that you've been approved. That's in essence what my recollection of the testimony is. I don't know whether if I'm answering your question or not.
So are you making a distinction then between the fact that J&M was approved by the commission just in general to do materials testing, whether it's for one job or the day contract or any job, and versus like if Ramos had approached her prior to the commission approving the use of J&M? Are you making that distinction?
I'm sorry, and I'm probably not following your question. There was no contract until January 2020. It was I'm sorry, I'm just not following the question. You can try it one more time.
Well, my question kind of morphed based on what your response was, but I'll go back to what my original question was. So I'm looking at Ms. Quintana's deposition, pages 12 and 13. And they're talking about handing out those flyers that you had discussed in your argument about, or whatever promotional material was that she was handing out to obtain jobs and bids. And it says, so then you turn that in, and then somebody contacted you from Lander. Who contacted you from Lander? Answer, so I turned it into Bert Ramos and Keith, and then they let me know there was a project, and that I came in. My whole goal was to come in at 3% to save my community costs. And so because I've experienced and I was willing to save my community that cost, I think that's why I was awarded. That would be a question for somebody else to truly answer. Question, so Bert Ramos and Keith Westengard were the ones who then contacted you. Answer, yes. So I just want to clarify, because I had heard at the beginning of your argument that Ms. Quintana had testified that she had never discussed the contracts or the work for Lander County with Ramos, but in fact, her deposition statement is that she was contacted by Ramos and Westengard to do work for Lander.
And thank you for helping me. And if your question was that about the day contract, I think that's unclear from the testimony and from the question, whether it was, I don't know what contract that was, what project that was, and Mr. Westengard, Mr. Ramos contacted J&M and said, hey, we've
Okay,
got a
but
project.
I don't think, but there's no dispute now that we can look at Ms. Quintana's deposition testimony and Mr. Ramos's deposition testimony, that the two of them did discuss J&M doing work for Lander County.
Yes, yes. After the arrangements, after they were approved, after J&M was approved, submitted all the paperwork that they needed to submit to be approved as a vendor for Lander County. Yes, there was no discussion. My understanding from the testimony, there was no discussion prior to that about Mr. Ramos playing any role in getting that approval process, going and successfully through the process.
Okay, so that goes back to my distinction question then. So she passes out her materials and her testimony is somebody contacted her from Lander and it was Bert and Keith. But from you just said, that contact only came after J&M had been approved by the commission to do work for Lander?
That's my understanding of the test. That's how I interpreted the testimony.
Okay. And is there any testimony that you could point me to that underscores your understanding?
Mr. Ramos has just shared with me that the scope of the work was all then that was all defined by the engineer, and the engineer is the one who ran all those projects, even though the work done for those testing services was directly with Lander County. But I don't think that answers your question.
No, it doesn't.
Point of order for the chair.
Sure.
At this point in time, usually in motions for summary judgment, additional testimony is not provided.
Okay.
If your client is going to provide additional testimony, that's fine, but we can swear him in and he can provide that testimony and be subject to questioning. What do you want to do?
I don't think it's necessary. I think we're good. I was just trying to help the commissioner understand, and it's it's me. It's not you, Commissioner Yen. It's me, trying to understand what you're asking. It's so I apologize that I'm not being very helpful.
No, I appreciate it. I just when you said that you believed that the contact from Bert and Keith happened after the commission approved J&M, the use of J&M. I just wanted to know if there was any evidence contained within the motions for summary judgment and the exhibits there too that supported that. And if not, that's fine. And like, Commission Counsel Chase said, we can't take new evidence. I just wanted to know if there was any of that evidence and I missed it in reviewing the papers.
Not that I can point to, maybe Ms. Bassett can, but
Commissioner, again, I can. This is Associate Counsel Bassett. In Mr. Ramos's deposition at page 39, lines 5 to 12, after much going around, I asked him questions about that same interaction. These two depositions were taken on the same day. And what I asked him was, like, someone had to authorize J&M to go out to the site. I was trying to get to the bottom of who met with because what you've heard it today. The issue you were getting at is the response keeps to being like, oh, nobody talked to J&M. No one told J&M they could go out there. There's no discussion, which, as we know from a practical standpoint, cannot possibly be true. J&M did not just show up and start doing materials testing without speaking to anyone from Lander County. It's not a possibility. So I finally said, someone had to authorize them to go out. Someone had to say, how much are you going to charge us? And Mr. Ramos's response was yes, and that was myself, Keith Westengard, and Marty Uvalde of Day Engineering. Because Marty is the one that was over the contract for Day Engineering. It's the Day Engineering contract. Marty was the one, Uvalde of Day Engineering, because Marty is the one that was over the contract for Day Engineering. Aaron Martinez was the one who said, I can only do it for 5%. If they can give you a better deal, put their boots on the ground. So who hired them? That would have been myself and Keith Westengard. And that answers to me the question of, what are we talking about? We're talking about the Day Engineering contract, and Mr. Ramos testified he's the one who hired. He hired J&M.
And are you referring to your exhibit 11 to the reply? I just wanted,
Which
could you just point me to that? I just want to read
the
the,
exhibit numbers are. I'm referring to Mr. Ramos's deposition.
because I know there's several excerpts of his deposition as exhibits. So which one?
I will have to take a second and look. I'm sorry, I don't know off the top of my head what they all are.
Okay. So that I will cede and let somebody else ask questions, and then if you can give that to me whenever, but I'm done with my questions. Thank you.
Thank you, Commissioner Yan. Commissioner Grunwald.
I have to ask Ms. Bassett, but I want her to finish what she's doing there.
Okay,
Sure.
any other commissioners have questions? Questions or comments? Commissioner Lowry? No, okay. Commissioner Tower?
Yeah, I do for Ms. Brew. Do you know what the initials JNM stand for?
Jody and Nettie, because I think it's Jody and Nettie. I knew this at one point. I asked because I asked Ms. Quintana Materials. Jody, Nettie Materials. I think that's what she told me. I'm not under oath about this, but that's what I think she told me.
I have another one for you. How would you define the term negotiate?
A discussion back and forth about, here's what we need. Here's what I'll charge you to do it. The terms, whatever the terms are, would be of a contract. She was, so, that's my very rough articulation.
I'm trying to understand how, so your argument is that never took place though. That we need this type of material and, can you provide that to us?
Well, so once that there was the arrangement that Lander County would make the arrangements for the testing services, but they had nothing to do with the scope of the work. And that document is called the scope of work. And it's an exhibit that's attached to a contract with the engineering company. And the contract with the engineering company lays out everything that needs to be done. There was testimony in multiple places in the depositions that it was the engineering company who made those decisions, not Lander County, not the testing services, because ultimately the engineering company is responsible. And they determine, for instance, if if, like J&M, those projects where they were not qualified. So I think, if I'm understanding your question, that was all defined by the scope of work with the engineering company.
All right. Thank you. That's all I have this time.
Thank you, Commissioner Teller. I think we're ready to answer Commissioner Yen's question, Ms. Bassett.
Yes, you're correct. It is reply exhibit 11 to the executive director's motion.
Okay, pages 38 through 39, correct?
Correct.
Thank you.
Commissioner Greenwald.
Ms. Bassett, I have 2 questions for you. So in the findings of fact that they agreed upon, number 13, that lists all the invoices,
Oh, okay.
are all the invoices that are in evidence, are they related to the day contract, or are they related to just invoices from J&M?
They're related to invoices from J&M.
And it's your argument then that with each of the invoices that were submitted at each meeting, Mr. Ramos had an obligation to disclose?
Correct.
With regard to 281A 400 paragraph 3, which says using public position to negotiate or execute a contract. So let me ask you about the term execute. That could mean signing a contract, or does the term execute also mean to carry out or put into effect the course of action?
I would say that it includes the second, yes.
Thank you. I have no other questions.
Any other commissioners have any questions at this point? Seeing none. I don't have any questions per se, but I have a couple comments. So there was a lot of testimony back and forth. In the old days, I guess you said that we had a little different philosophy, that we would use the hammer as opposed to use our training. So, and that is our mission, and our goal is to train our public officials and to train our public employees to make sure that they understand what the ethics laws are, and there's quite a few of them. Whether you live in Battle Mountain, or you live in Carson City or Las Vegas, or wherever you live, they apply to everybody. As Ms. Bassett said, it's not an excuse not to know them, although there are a lot of them. And if you don't have training on those, and your supervisors don't give you that information, I can see where you could be in that situation. It's not an excuse for your behavior, though. Another comment I wanted to make was, you mentioned, Ms. Bree mentioned that Ms. Quintana was gathering all her papers and filing all of her paperwork. I'm assuming you meant to form her LLC.
Correct.
And whatever various applications needed to be filed.
Correct.
Which I found interesting, that she followed all those rules, but yet it did not have any kind of a written contract, which I understand apparently it's not necessary with Lander County. So there's a contract verbally vis-a-vis through the parties that asked her to do the services, which I believe was Mr. Ramos and Mr. Westengard. And that's what I gathered out of the testimony. One last comment is, you mentioned that you had, actually, this is a question for you, Ms. Brewer. You mentioned you had a dispute with one of the undisputed facts. So I wanted to hear which specific undisputed fact did you have a dispute with?
So one of them was in the executive director's motion. They stated as undisputed, the terms for J&M's services were negotiated between Quintana and Ramos, and she cites to the Quintana Depot, pages 12.
That one, I'm sorry.
I don't think that she cited to the depot or to the exhibit number.
Okay.
She
You
cites-
wouldn't have a number, sorry.
Sorry, yeah. So she cites to the depot, the Quintana Depot at pages 12 through 16. And if you look through, if you read pages 12 through 16, there is nowhere in there that says anything about any negotiations between Ms. Quintana and Mr. Ramos. So that was, so that was one of the facts that she says is not undisputed, which is, yeah, I believe it is disputed. And she also said, no evidence that anyone considered the invoices to be a contract. That's what Ms. That was in her undisputed facts. Ms. Quintana testified specifically, there was no contract with any of her clients.
Okay, one last comment, this is off something that you had stated earlier in your presentation. You were talking about the small town, Battle Mountain, you kind of know everybody, everybody knows their business. But at the same time, I think it was Mr. Westengard didn't know the relationship between your sister, Mr. Ramos, and the significant other. So that's exactly why we have rules for disclosure. That's why, because we don't know, as you said in your testimony, we don't know what we don't know. That's why we have these particular rules. You can make assumptions about who knows who in a small town, and you're probably going to be wrong sometimes. And in this case, I think you may have been wrong. So those are my comments, and I'm ready for a motion. I see Commissioner Yen, please go ahead.
Yes, so I want to say that I think 400 subsection 2 was very close in my mind, but hearing from the Associate Counsel Bassett that buying local and money savings, that those are still questions of fact, then obviously I can't grant summary judgment in Mr. Ramos's favor on that. However, I do feel that I think their summary judgment is appropriate on NRS 281A.400 subsection 3. I think that the deposition testimony of Ramos and of Quintana show that there was a negotiations such that that statute's been implicated and a violation did occur. And I also find that there were 12 violations of NRS 281A.420 subsection 1 as a disclosure was required. And so I would make a motion that for myself, the commission's reviewed the entire record for this record of matter and has considered the pending motions, arguments of counsel, and I move to grant summary judgment on the executive director's motion relating to NRS 281A.400 subsection 3 and NRS 281A.420 subsection 1 and deny the relief requested by subject Ramos.
Any comments on that motion before I ask for a second?
You gotta have a second. I second that motion.
Okay, I have a second from Commissioner Grunwald. Any comments?
I have a comment. You said 420 subsection 3?
For 400 subsection 3, 420
Okay.
subsection 1.
All right, I just want to make sure I heard that correct. Thank you.
All right, all those in favor say aye.
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 Those opposed? Hearing no opposition, the motion carries unanimously.
Vice Chair Dufferin?
Yes.
There's a remaining issue of whether or not the conduct is willful or non-willful.
Okay.
I would recommend that the commission direct the parties to do briefs specifically on those issues and to return to the commission, and I can schedule with them a meeting date and give them a briefing schedule on those issues, because we have recommendations on whether this should be a fine case, whether there are mitigating factors, and some have already been brought up. So I think it would be appropriate for the commission to receive briefs on those issues.
And that makes sense to me. Do we need to include that in our motion, or is that just something on the record?
I believe you should include it as another motion so that you give me authority to go ahead and do a scheduling order for the briefs and set another date to consider that.
And that would be for the willful versus non-willful?
Correct.
I'll make that motion. A second?
Second.
Second it.
Here, Grunwald, Ms. Grunwald first this time. So I have a second. All those in favor say aye.
Aye.
Those
Aye.
opposed? Hearing no opposition, motion carries unanimously. Thank you, everybody.
May I ask a procedural question or two?
Sure.
So the motion was denied for 400 section 2 because Commissioner Yen said there was a question of fact. Does that mean that the adjudicatory hearing will go forward on that remaining count?
I'll let our commission counsel answer that.
Yeah, the motion for summary judgment only resolves what's before the commission. So anything that's unresolved by today's ruling would be set for the adjudicatory hearing. What I would intend to do is after the meeting, perhaps we can schedule a settlement conference so that maybe any other allegations that were not dispensed with, maybe there is a potential for settlement. Otherwise, they would be scheduled to go into that adjudicatory hearing.
So, and is there an appeal process for, because our motion was denied, all of our on all counts was denied. So is there then an appeal process for that it would, I know when I'm in court, if my motion for summary judgment is denied, now I have to go have a trial. And so that's what I'm trying to understand procedurally.
I'll help a little bit with that, Vice Chair
Please go
Dufferin.
ahead.
Under administrative rules, we follow 233B, and administrative rules allow a petition for judicial review once there is a final determination. I do not believe there's a final determination at this point in time because the deciders of fact have not determined whether it's willful and non-willful, and they have not held an adjudicatory hearing on those other matters.
Okay.
The commission certainly could dismiss those other matters based upon the facts rendered, or they could find a violation on those other matters. So at this point in time, there's no final decision.
Okay, thank you. I may have some more questions, but I can go. Thank you.
Thank you. Let's go back on the record with item 7, and Chair Wallen, please take over.
Thank you, Vice Chair Dufferin. Next item is item 7, delegation of authority to the Chair of the Nevada Commission on Ethics. The Chair to represent the Nevada Commission on Ethics Commission at the 2023 legislative session or any special sessions called, including limitation, confirmation of authority to direct staff pursuant to NAC 281A.155 on matters relating to the Commission's proposed bill draft to amend NRS Chapter 281A, Nevada Ethics and Government Law. I'd like to call the item and ask the Executive Director for his presentation.
Thank you, Chair. This item, I worked with the Commission Counsel on. I think she also consulted the Attorney General's office. Last session, we had designated 2 individuals to be the point person on legislative matters. And my understanding is that the AG's office said that could become a committee, and then you need to follow the open meeting law. And so this delegation of authority allows you as the chair to be the point person if there is an item as we go back and forth with LCB throughout the legislative process in any very tight negotiations and representation of our bill that has been submitted. And so we have time, in these early kind of back and forth, we'll have regular meetings where we can bring items forward. But as we get going into the session, this would designate you as the voice of the body to help direct me as the executive director on whether or not to accept or reject, amendment proposals and those types of things. So that's what this item is for.
Okay. Commissioners, any questions? Right, I'll entertain a motion.
I'll move that we approve that item.
Second.
All right. Should I abstain? No. Okay. All right. All those in favor say aye.
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 Opposed? Right, motion carries. Next item. The Executive Director's Agency Status Report. Executive Director Armstrong, please give us your presentation.
Thank you. This is
Oh, yes, Commissioner Lowry.
I apologize. for interrupting. My apologies to the chair, vice chair, and fellow commissioners. I have to excuse myself at this time.
Yes, that's all right. I knew that you had to leave early today, So thank you so much for participating, and we'll see you next time.
Thank you.
Okay, thank you. Bye.
Wait, this is Director Armstrong. We're on agenda item 8, my report. I will be concise with it. The first item is education and outreach. I'm going to put in some charts and stuff on social media once a quarter. So this is that meeting. You see we got 171% growth in LinkedIn followers and 37% growth since the start of the year in Twitter followers. And there's a little fact at the bottom of the page what that means. So in May 2021, Commission on Ethics tweets were seen 958 times by people scrolling through their phones or on their line. And then May of this year, it was 7,285. So that just shows you that people are seeing the content that we are putting out. On the second page of the report, you'll see the training and technical assistance schedule coming up. Since then, we've added also the city of Elko. So the last week of June, I'll have a rural tour, kind of do a loop.
Are you gonna stop in Lander County?
I do not have a stop scheduled in Lander County this time.
Just thought I'd ask.
And then we also added to this, we've got some dates in July, and then the Nevada Civil Attorneys Conference. And then also, they're gonna have a day at the Nevada League of Cities that's focused on the culture of good governance. And so I'll be the kickoff speaker for that particular day in I think August in Las Vegas. So that'll be
nice.
yeah, that'll be find like a
Wear shorts.
yeah. Our online learning system, we have an update since the report was submitted. That's looking like we'll get budgetary authority at the August IFC to then engage with a vendor and getting the online training system up and running. So that's great news. That was approved. You'll see our budget update for this year. And these are projections on what will be left at the end of the year. Obviously, personnel based on the vacancies, there's going to be money left on the table. In-state travel, we had, I don't remember which variant it was that took us out at different times, but that was we'll be leaving some of that in-state travel money, which we don't like to do, but it's not normal time. So I think that will be understood. You'll see we have a projected $241 deficit in information services. So we'll do a work program to shift from one of the ones where we have additional money. I always kind of I don't bicker with Executive Assistant Pedroza. She just helps tell me the fiscal rules on basically anything that plugs in has to be charged to information services, even if it's not really like a computer or something. So I always try to figure out a way to use a different category, but that's where we are in terms of the budget update. We're looking good. We've got a work program. ASD is working with us to close out all the year-end items. There's a branding, so a quick branding check-in. I've sent the survey on the branding project. We have some responses already. We'll get responses from commissioners and staff on that, and then have some presentation at the August meeting for you all. Also included in your materials is the quarterly case log. And I will just briefly say that in addition to what is on here, we received 11 complaints were filed on Thursday, so that was a banner day for us, and then
Filed by the same person or?
there's kind of two sets there.
So two
So there's
sets.
a set of 4 and a set of 11 and a set of 7.
So two different issues?
Yeah.
Okay, thank you.
And then we got two additional ones today. So we'll add those next time. I think the real story is that as you look, we've completed everything from fiscal year 2019. That's done. There's in some monitoring. We have for fiscal year 2020, we have a deferral agreement still hanging out there, which should be done. But otherwise, we're just waiting for adjudicatory hearings. And then fiscal year 2021, we have everything is either set and is in compliance mode, or we have adjudicatory hearings. So to the extent that there's old cases hanging out there, they're either scheduled for an adjudicatory hearing or just about to be wrapped up. So I feel we're really caught up in terms of the case log and any sort of backlog. Obviously, we're in for a busy fall with adjudicatory hearings and some motion hearings like we had today. But we're able to process the cases that are coming in and get them investigated in a timely manner. So that is looking really good at this point. And so that concludes my executive director's report.
Commissioners, any questions of the director? I just want to commend staff for getting the backlog caught up, and, you know, this is great, especially since you just got another 11 or 12, 13, whatever it is. So I know we've got a lot of advisory opinions still in the pipeline too, so you guys are definitely keeping busy, but you're getting it done. So thank you very much for all your hard work. Appreciate it. Is there a motion to approve the executive director's agency status report as presented?
So moved.
Second, is there a second?
I second.
All right, all those in favor say aye.
Aye.
Aye. Opposed? Motion carries. Next item, item 9, commissioner comments. Are there any commissioners that wish to make any comments or putting in additional items on our agenda for our meeting in August, right? There will be no meeting in July so far.
Actually, we anticipated a meeting in July, however, that just got moved to August, so we do not anticipate a meeting in July, to my knowledge. Executive Director Armstrong, do you have any other information on that?
No, that's correct. There was going to be a meeting July on our short timeframes, but they agreed to wait a couple weeks and go in August.
Okay. Right. And then, so that's it. So no comments from the commissioners. All righty. Thank you. Public comment. Are there any members of the public present that wish to make public comment?
This is Director Armstrong. There are no members of the public present. And I will defer to Executive Assistant Pedrosa to see if anyone is on Zoom.
Commissioner Van Hassen.
There are no members of the public on Zoom.
All right. Sorry, let me go back to Commissioner Yen. I'm sorry, I didn't see your hand.
No, that's okay. Thank you, Chair Wallen. I just wanted to confirm, so no July 20th meeting now? Was that-
Correct.
Okay, thank you. Thank you.
I just want to, that includes review panels, correct? Executive Director Armstrong?
Maybe. I think yes, I think that's correct. But if there is, we'll let you know. It won't be on the 20th. We'll find a day that works for those 3 panel members.
Yeah. Okay.
And there might be one hanging out there that if they don't waive the time frame, we need to do a quick panel on, but I don't think so off the top of my
Right.
head.
Yeah, you can work it out with the people that are on the review panel.
Yep.
Doesn't have to be on the 20th. Okay. All right. All right, back to public comment. Executive Director or Assistant Pedrosa.
There are no members of the public on Zoom.
All right, well, thank you. Now entertain a motion to adjourn.
I'll make it.
Is there a second?
I second.
All right, all in favor, say aye.
All right.
Opposed, motion carries. We will have a review panel, which consists of myself and Commissioner Towler. Commissioner Lowry is excused. So we'll just give like about a 5-minute break and we'll start in, all right?
Bye all,
everyone.
thank you.
Thank you.